employment and labor. Oftentimes, you have a new hire, and you make an offer to them through an offer letter or a more formal employment agreement. And this, and for the actual employees in the company, a word of advice is to make sure that you've actually read the employment agreement thoroughly and that you understand the compensation that you're receiving in terms of stock, options, and equity in the company. A lot of times, I've met a number of employees who work and have worked at startups who, where the startups didn't actually have all of their documents together, and they were taking a very long time to actually give the equity to employees. And what that led to is some employees had to leave before they were even given documents showing them how much they owned in the company. And also, if you don't have those documents in hand before you actually start working, what happens is that you lose negotiating power with the startup company. The startup starts to become more valuable. They have a stronger position. You've been staying in the company longer. You don't have other offers on the table, whereas initially you might have. And so your bargaining power becomes much weaker as an employee. So definitely, you want to have those agreements on hand, and I've seen many times where the startups were not prepared with that. So the PIIAA, again, that's the Proprietary Information Inventions Assignment Agreement. You want to make sure that each of your employees signs that, giving ownership of the IP to the company. And in the agreements, there are often restrictive covenants such as non-competes, non-solicits, and non-disclosure agreements. So the non-compete says that you can't work for a business that's competing with the company while you're working for the company, and also for a period of time afterwards. In California really is very employee friendly, and so in California, non-competes are basically prohibited unless you're in a special situation where you've actually sold your company. Then courts will enforce non-competes against the selling founder. Non-solicits are that you won't solicit any of the employees to come work for you in a new company, or solicit any of the companies to move into your company for a period of time. And non-disclosures are for confidentiality purposes. You want to make sure that your proprietary information stays in your company and doesn't leak out.